14. Chapter 2 Formation of Contracts. Introduction. Consent is a declaration of intention to be bound by an obligation. A person has to express his willingness to create an obligation on himself, or give up some or all of his proprietary rights. In modern times, individuals have relative freedom to decide on their own rights, especially property rights, without the interference of a state or another person. So individual cannot lose his property right unless he himself wants to lose it except by expropriation. Contract is one of the major areas of law that recognizes autonomy of individuals. The 17th century John Locke's theory of social contract and Adam Smith's laissez-faire gave political and economic justification for individual autonomy. Such individual autonomy is expressed through consent, i.e., an individual can determine his own fate, freedom of contract. So in a contract, a person should know the obligation he is going to carry out and the benefit he is going to get or lose. Knowledge is not enough, he should also agree to such obligation/benefit. Agreement is not still enough. The person should also agree that if he fails to meet his obligation as agreed, the state machinery may be used to force him to carry out his obligation. Unless a person clearly knows what rights and obligation are to be created, varied, or extinguished, it is impossible to claim that he has agreed. That is what is provided under Art. 1679. The parties have to know means they have to define their obligations, undertakings. Moreover, they have to agree to be bound. Therefore, contract cannot be imagined without consent of the parties, i.e., contract is dependent on the consent of the parties. www.abyssinialaw.com. Page 15. Non-binding agreements, mere domestic or social agreements, are not usually intended to be binding and, therefore, are not contracts. E.g., a father told his son that he, father, will reward 10,000 bear if the son scores 4.00 points in his first semester exam. A binding contract is usually in the nature of a commercial bargain, involving some exchange of goods or service for a price. In considering whether sufficient intention to create a binding contract is present, two situations are possible. A. Where the parties expressed by denying the intention, for commercial agreement, e.g., a written commercial agreements described itself merely as an honorable pledge and stated expressly that it was not to be subject to the jurisdiction of any court. B. Where the parties do not expressly deny intention to create legal relation. It is in each case a question of construction for court to decide as to whether a contract is intended. Thus, in commercial agreements, there is a refutable presumption that a contract is intended, but in social or domestic or family agreements there is a refutable presumption that no contract is intended. But note that in each case the presumption is refutable by evidence to the contrary. E.g., 1. C persuaded her sister, P, to sell her own house and come and live in C's on condition that C would give her house to P by donation. After some time C injected P from the house and refused to honor the donation. P claimed damage for breach of donation contract. Is P correct? E.g., 2 B and O habitually ride in each other's cars. While in O's car, B was injured due to O's negligence and sued for damage under Ethiopian law of carriage. B claims that. www.abyssinialaw.com. Page 16. There was contract of carriage between him and O since he, B, contributed to the petroleum cost. Is B correct? E.g., 3. Hawassa University and SNNPR Supreme Court entered into the following agreement. Memorandum of Understanding. This Memorandum of Understanding is signed on this day of 25th February between Hawassa University and SNNPR Supreme Court. By this agreement, 1. The court agrees to make internet service available for the law faculty students of the university. 2. The university agrees to make conference rooms available to any need of the court. 3. The university agrees to give free library and internet service to any judge of the court. So, what is the student asker? Generally, the mere existence of agreement to be bound by defined obligation does not necessarily make contract. It is necessary to identify whether the parties intended only moral obligation or legal obligation. If parties agree to be bound morally only, the agreement is not a contract since it cannot be enforced by state backing. For a contract to exist, parties must agree that any violation of the obligation would be punished by using state machinery. Therefore, the phrase, agrees to be bound thereby, in Art. 1679 implies the party's intention to take any controversies in relation to obligation to court, thereby allowing the court to interfere in their relation. Meeting of mind, Art. 1680, contract occurs when the minds of the offerer and offeree meet upon common object of the contract. This meeting of mind is called consensus ad idem, i.e. consent to the matter. The declaration of both parties must relate to the same matter. This is what Art. 1680, 1. www.abyssinialaw.com. Page 17. Provides. However, since meeting of mind is inferred from offer and acceptance made by the parties, the law is often concerned with the objective appearance of the offer and acceptance than the actual fact of the intention of offeree or offerer. The person is bound whatever his real intention may be if a reasonable man would believe that he was assenting to the terms proposed by other party, and upon such belief he enters into a contract with him. Parties are to be judged not by what is in their mind but by what they have said, written, or done. So no body could be bound by an intention, a state of mind, which is not included in the offer or acceptance, i.e. a person cannot claim to avoid a contract by citing reservations or restrictions that has not been made clear to the other party through offer or acceptance. Art. 1680, 2. When the law enforces the intention, consent, of the parties, it does so that the party's reasonable expectation is protected. Any intention of a party not included in the offer or acceptance never forms part of the contract. Therefore, obligation that one of the parties wants to be included in the contract never binds the other party unless such party knew and agreed to be bound by it. In short, Art. 1680 is a repetition of Art. 1679 and hence may even be deleted from the code. Formation of contact involves the criteria that the state uses in order to determine whether or not it has to execute agreements of persons between themselves. In other words, the state uses the following yardsticks to check whether or not persons have made a law that binds them. A. Capacity. B. Consent. C. Object. D. Form, if any. All contract involve the element of capacity, consent, and object, i.e. contract cannot be imagined without capacity, consent, and object. However, form is required for few contracts only. www.abyssinialaw.com. Page 18. 2.1 Capacity. Although human beings are subject to rights and duties from the moment of birth to death, some may not be entitled to exercise such rights and duties. Still others may exercise only some of their rights. Minors and judicially interdicted persons cannot enter into a contract. However, when a legally interdicted person enters into a contract which he was prohibited from, such is not limited to incapacity but also extends to illegality as per Art. 1716. The same holds true for special incapacities indicated under Art. 194. The detail of incapacity has already been discussed under Law of Person. 2.2 Consent, Art. 1679-1710. 2.2.1 Communication of consent, Art. 1681. Consent is expressed either in the form of offer or acceptance. Offer and acceptance are ways of communicating one's own intention to be bound by an obligation. Therefore, offer or acceptance is declared to another person by ordinary ways of communication. These ways of communication are oral, written, signal, and conduct. 2.2.1.1 Offer. Offer is laying down contents of would-be contract, i.e. indicating the respective obligation of each would-be parties to the contract and informing the same to them with the expectation of response from them. Moreover, offer contains the intention of the person making it to be bound by the content of the offer. In short, offer contains three important elements: the content of the contract, the agreement of an offerer to be bound, and request of the offerer to the offeree to be bound by the offer. The person making the offer is called offerer. The offerer has autonomy to choose any of the four ways of communication: oral, written, signal, and conduct. He/she may even choose the ways. www.abyssinialaw.com. Page 19. That the offeree shall use to give a response, Art. 16811, 2. So offer may be made in writing, orally, or by signs or conduct, Art. 1681, 1. Written declaration of offer is when all the elements of offer are reduced in writing on a paper or electronics and delivered to the offeree. Then the offeree understands the intention of the offerer by reading the paper or the electronics containing the offer. So, if the offeree cannot read for whatever reason, there must be someone who reads it to him. For example, if the offerer sends his offer through email or fax, such as written communication of an offer. Oral commutation of an offer is when the offerer uses voice to tell to the offeree the contents of the offer and the offeree uses hearing, ears, to know what the offerer is communicating to him. So using telephone, telegram, e.t.c to communicate an offer is oral communication of offer. In short, the offerer uses his mouth and the offeree uses his ear for communication. Signal communication is of two types: gesture and object placed to give information. Gesture is one of the four ways of communication. Mute or / and deaf people use such way of communication. Such person makes an offer by using signal communication. Nodding head, shaking hands, and hammering down in an auction sale are also communication by gesture. Objects may also be used to express an intention. For example, in a commodity exchange market, objects are utilized to indicate intention to be bound. Communication of offer by conduct is when the offerer performs partly or wholly the obligation that he will perform if the contract is entered into. Earnest is the best example of offer by conduct, Art. 1883. In this case, the offeree uses the combination of his sight or / and ear and mental intellect to know and understand intention of the offerer. Offer by conduct is an implied offer because the offeree is forced to infer the offer from the conduct of the offeree. Offeree may infer different obligation from what is intended by the offerer. So care must be made by the offerer that his conduct is clearly understandable to the offeree. www.abyssinialaw.com. Page 20. In principle, an offer is binding on the offerer only if it is addressed to a specified person, Art. 1687 1688. The reason why the offerer is expected to know the offeree and address his offer to him may be to make sure that the offerer has intended to be bound by his offer and to avoid the possibility of multiple acceptances for a single contract. The person may want to advertise his product or service without any intention to be bound by the content of the advertisement. The person advertising a product or service may not have the product or service at his disposal, and he may be making a market study, i.e., he may want to know the demand for his product. This means although he states the type of product or service he wants to supply and the price he expects, he might not intend to be bound. E.g., a certain college releases the following information on Addis Zamina newspaper. Our college is going to open degree program in business management. Tuition free is bare $500 per month. It takes only 30 months to complete BA the program. Any person who has completed preparatory or has degree in any other field is invited to apply soon. A person may also release the idea moving in his mind to a friend or even to the public, either to ask advice or to know public opinion so that he can decide whether or not he has to make an offer. Therefore, if a person does not make his intention known to the beneficiary of the declaration, such declaration shall not be taken as an offer, Art. 1687, a. E.g., Abeba told his mother, Alematu, that he is happy if his father, Belachu, accepts his Mercedes-Benz S. 2007 model as donation. Alematu told the same fact to Belachu. Moreover, if offer is communicated to the public, many may come to accept the contract. This creates inconvenience of choosing a person whose acceptance should be binding on the offerer. So the easiest way out of such inconvenience is to consider the declaration that become the source of such controversy as non-binding. In such case, ultimate goal of www.abyssinialaw.com. Page 21. The declaration of intention shall be advertisement of the product or service. Therefore, the following declaration of intention are not offer but advertisement. Sending price lists or tariffs, Art. 1687, b. Here, the price list or tariff may be sent to specified address or a specified person, but still such act should not be taken as an offer because of the following reasons. Dedication to be bound is missing. Such price list/tariff alone never indicates the intention to be bound. The document sent contains the price list/tariff, which may be taken as content of the contract, but the declaration of intention to be bound is missing. Such is, therefore, neither a written nor oral offer. Signal communication is using body gesture or identified object as an expression of one's intention, but sending of price list/tariff does not fulfill such requirement. Offer by conduct is beginning to perform would-be obligation but not sending price list. Price list/tariff never indicate all terms of the contract, such as due date, place of performance, quantity, etc. So it is not complete even if the person to whom it is addressed responds positively. Art 1695, 1. Customarily, sending of price list/tariff is taken as an advertisement the price list/tariff might have sent to many, creating the problem of multiple acceptance. E.g., One Moha Bottling plc has recently started producing beverage in the Hawassa, and it prepared the following and sent it to Tatesi Hotel. Moha is ready to supply the following Pepsi products with the corresponding price: product unit price Pepsi Cola 0.8 Bear, Mirinda 0.75 Bear, Spritz 0.6 Bear, Mirinda Tonic 0.9 Bear. www.abyssinialaw.com. Page 22. E.g., 2 General Garment plc distributed the catalogue of its services to graduating students of Addis Ababa University. Posting up price list/tariff and catalogue in a public place. This declaration of intention is not an offer, mainly because there would be multiple acceptances if the declaration of intention is to be considered an offer. Everybody may have an access to the declaration. Posting is announcing to a public by using all possible means such as press, radio, and television. It also includes affixing a notice on board, wall, poles, and car, or on any other object. E.g., One Commercial Bank of Ethiopia published the following information in Ethiopian Herald. Commercial Bank of Ethiopia is intending to employ any person having LL.B degree. Workplace is Hawassa, salary is bare 3,500 per month. Employment is permanent. Interested applicant should submit his CV until January 20, 2008. Display of goods for sale to the public. Almost all sales are sale at open market. Every person passing by can have a look at the goods and can easily infer that the goods are ready for sale. But there may be multiple acceptance and the content of the contract is also incomplete. Display of goods does not include some of the contents of the contract, such as performance date and place and quantity. Display of goods could at most contain the type of goods and their prices. See example given by G. Kristchanoviwis. Sale by auction, Art. 1688. It is inviting possible offerer to come and make an offer. Many may come and make an offer, and the person who invited such offer may freely determine which to accept, thereby rejecting others. The invitation may either be to buy or to sale. See auction sales from newspaper and report to your instructor in a class. Read also Art 2403-2407. www.abyssinialaw.com. Page 23. Public promise of reward, Art 1689. As stated above, a declaration of intention to be bound by specified obligation becomes an offer only if it is addressed to an identified person. An exception to this principle is public promise of reward. Public promise of reward is notifying the public that whosoever performs a certain act indicated in the notice will be given benefit of proprietary nature by the promiser. It is a reward that is promised to be given for an extraordinary performance or coming across an object lost or person hidden. The promise is public because it addresses to all which performs the required act. No discrimination is made on those who may benefit from the promise. If a promise of reward is to a specified person or group of persons, it becomes an ordinary offer if it is made to be known to such a specified person or group of persons. In such case, the promiser can use any means to communicate his intention to the specified person or group of person. It is enough to prove that the promisor has really intended his declaration of promise to reach the specified persons or group of person. Such intention can be ascertained from the circumstances and especially from the means that the promisor uses. For example, if the promisor uses public media such as press, radio, television, electronics, and etc. to which the specified person or group may have access, the declaration of intention may be taken as an offer if the specified person/group of person has come to know such declaration. In case of public promise of reward, the media of declaration never matter and the person who performs a specific act in the promise need not know the promise. Art 1689. In short, a public promise of reward is special offer. Exercises identify public promise of reward and ordinary offer. 1. Sir Alex Ferguson gave the following press release in 2007: if Cristiano Ronaldo scores 30 goals in English Premier League 2007/2008, I will give him a large amount of money. www.abyssinialaw.com. Page 24. 2. The government of USA publicized the following information in Internet: whosoever reports the whereabouts of bin Laden shall be rewarded $1 million. 3. The following declaration of intention was broadcasted in Ethiopian television. Our father, Ado Akubabir, he left home on December 12, 2007 and has not yet returned. Ado Akube is 49, tall, very handsome, bold, and dressed white gabardine suit on the day he left home. Whosoever reports to us the whereabouts of our father will be rewarded. His sons, Bekil and Zelalam. Please give at least 4 other similar examples. Effects of offer, Art. 1690, 1691, 1693, 1, 2055. This is the effect: the offer is to bind the offerer. Once the offer is made, it means one side of the parties to the contract, the offerer, has agreed to be bound. Offer contains would-be obligation, i.e. the content of would-be contract is defined by offer. This indicates that the conclusion of a contract is partly completed. The party making an offer cannot change his opinion. That is why it is necessary to distinguish an offer from mere declaration. A person making mere declaration of intention can change its declaration at any time it wants for whatsoever reason without any legal liability for unreasonable and arbitrary change of its intention. It is obvious that if declaration of intention is not an offer, it is full autonomy of the person who declared such intention to live up to his declaration or change his intention for whatsoever reason. However, an offer cannot be changed by the offerer for unjustified reason. An offerer who changes his offer partially, makes some modification to the content of his offer, or totally, refusing to be bound by his offer, is liable for any material damage on the offeree. If offer is binding, where does it begin to be binding? There might be time gap between the offerer's release of the offer and the offeree's reception of the same. This is true. www.abyssinialaw.com. Page 25. Especially when written form or conduct is used to communicate an offer. For example, an offerer may use letter or fax to reach the offeree. So the offer begins to be binding at earliest from the moment the offeree knew its content. Any declaration of intention to be bound by a contract may not even be considered as an offer for the sole fact that it has not yet reached the offeree. Art. 1687. So the offerer can freely change the content of his offer or totally withdraw it before it reaches the offeree. Art. 1693, 1. The offerer can make his offer not to reach the offeree by informing the offeree that change has been made to the content of the offer or that it has been withdrawn. This has to reach the offeree before he receives the offer or at latest before the offeree takes decision that affects his material interest on the assumption of the offer. Art. 1693. This means an offer may be withdrawn or modified as far as the offeree has not incurred expenses with a view to concluding a contract with the offerer. So what is crucial is not the time when the offeree received the offer but the decision he has taken due to his knowledge of the offer. The offerer can change or withdraw his offer at any time before the other takes decision that affects his interest. So the burden of proving that the offer is changed or withdrawn after he takes decision that affects his material interest is on the offeree. Changing or withdrawing an offer is a fault, Art. 2055. Change or withdrawal of an offer is not a fault when it is withdrawn or changed. A. Before the offeree knows the offer, or B. At the time the offeree know the offer, or C. At any time before acceptance for justified reason. Even if modification or withdrawal is made contrary to the above precondition, the offerer may be liable only if the offeree proves that the offer is the cause for his loss. How long does the offer bind? As we see above, offer is binding from the moment the offeree knows its existence. Such tells us the time then the offer begin to produce effect. If it begins, it must also end somewhere. Everything that has beginning must also have end. The offerer should be given an opportunity to be released from his offer, or else how long will he wait for acceptance? The offerer may himself determine how long the offer. www.abyssinialaw.com. Page 26. Remains binding. For example, an offerer may indicate in his offer that acceptance be made within 10 days from the moment the offeree knows the offer. After expiry of such 10 days, the offerer can change, modify, or withdraw his offer for whatsoever reason and without any liability to the offeree. Art. 1690. In case the offerer fails to fix time limit for acceptance, the offer remains binding for reasonable period only. Art. 1691. Reasonable period indicates the time that the offeree needs to understand the offer and decide to accept or reject it. So if the offeree remains or unable to decide within such reasonable time, the offeree will no longer be bound by his offer. But the crucial issue is how long is a reasonable period. The length of reasonable period should be the average time that the average person may need to determine on the offer. The circumstance of the offeree should not be taken into account to determine the length, since contract is not a charity and the offerer is running for gain and has no legal or moral obligation to sacrifice for subjective weaknesses of the offeree. However, objective criteria such as the existence of current price for the subject of contract, market stability, and complication of content of the contract should be taken into account. 4. Example: if offer is made for sale of coffee in Ethiopia, the offeree may be expected to respond in hours, and a response coming after days may be taken as not coming within a reasonable period. On the contrary, an offer for a construction may be reasonably binding for weeks. Market stability is also very important to determine the reasonableness of the period, since in case of market instability, price changes now and then, thereby affecting the decision of both the offerer and offeree. So when there is market instability, reasonable period should depend on the frequency of price change. For example, in Ethiopia, price of fuel is revised every 3 months, and such revision probably affects the advantage of either parties. So court should consider such other similar facts affecting market price. Whenever the court is not convinced that the period is reasonable, it should conclude that the period is unreasonable, since any doubt should benefit the defendant. Art. 1738. Whosoever claims the right has a burden to prove the existence of such right. www.abyssinialaw.com. Page 27. We have to bear in mind that if the acceptance reaches the offerer after expiry of reasonable period, the offerer has a duty to inform the offeree the lateness of the acceptance by using the speediest medium of communication available. Such medium should at least be as speedy as the medium used by offeree to send his acceptance. Using the speediest medium is not enough. The response should be made at the moment the offerer receives the acceptance. So if the offerer fails to reject the acceptance immediately, the offeree has the right to claim that the acceptance was given within reasonable period and hence contract was concluded. Art. 1691, 2. The third ground that terminates the effect of an offer is the offeree's rejection of the offer. Art. 1690, 2. Rejection of an offer is either making modification to the content of the offer or sending a no answer to the offerer. Offer is deemed to be rejected where acceptance is made with reservation or does not exactly conform to the term of acceptance. Art. 1694. Art. 1690, 2, expressly provides rejection of offer as a cause of termination of offer where the offer contains fixed period of time for acceptance. The same should apply to cases under Art. 1691. There is no logic for offerer to wait for an expiry of reasonable period once the offeree rejects the offer. Even one can argue that once the offeree rejects the offer, it shows that the reasonable period has already expired, since reasonable time is the time that is sufficient for the offeree to respond. But since reasonableness should not depend on the subjective situation of the offeree, we may still say that rejection of offer may be made before expiry of reasonable period. But still the rejection releases the offerer because there is no justification for the offeree to get time to revoke his rejection and claim to accept the offer simply because the objective reasonable time has not yet expired. There is a less possibility that an offeree who once rejected an offer could come to accept the same, and forcing the offerer to wait such change of mind is fooling him and inequitable. www.abyssinialaw.com. Page 28. 2.2.2 Acceptance, Art 1681-1685, 1689, 1, 1694, 1893, 3. Acceptance is a positive response to an offer, i.e., it is a declaration of intention to be bound by each and every contents of an offer. In short, acceptance is a yes answer to all the contents of the offer. Any slightest modification made to the content of the offer is considered as rejecting the offer and making an alternative offer, Art. 1694. So the offeree must take care in giving response to an offer. He has three alternative answers to an offer: the yes answer, which means accepting the offer as it was made; the no answer, which means totally rejecting the offer; or acceptance with reservation, which means having reservation or alternative proposals for some of the contents of the offer. So where acceptance is made with reservation or does not exactly conform to the terms of the offer, the offeree must remind himself that he is taking the position of the offerer, and the offerer then becomes an offeree, Art. 1694. That means the offeree, the current offerer, is bound by the new offer he makes until the time limit he fixes for acceptance expires, Art. 1691, or until he reasonably expects the other party to decide on the new offer, Art. 1691, 1. E.g. Point 1. Abeba wrote the following email message to Tuffa. Dear Tuffa, how are you doing? I am very fine. I am going to sell my Toyota Land Cruiser 99 model automobile to you to bear 30,000. Delivery and payment date is on January 20, 2008 in Addis Ababa. Tuffa may respond in any of the three ways. Thank you, I am lucky to buy your car. Thank you for your concern, but I do not need any automobile now. Thank you. I am very much happy to buy your car, but the delivery place should be in Awassa. Acceptance. How acceptance is made. Since acceptance is communication of intention, like an offer, it can be made in all possible ways of communication. So, the offeree can use writing, oral, sign, or conduct as www.abyssinialaw.com. Page 29. A means of communication. The medium of communication never matters. The offeree may use letter, press, telex, email, etc. to communicate his acceptance in writing. He may also use telephone, telegram, video, radio, television, etc. as a medium of oral communication. Signal communication is showing certain publicly known physical gestures, such as shaking the hand of the offerer, nodding head, or using certain objects publicly used to indicate intention, Art. 1688, 2. Signal communication usually requires the physical presence of both the offerer and the offeree at the same time and at the same place. Communication of acceptance by conduct means performing partly or fully the obligation proposed by the offer or benefiting from the rights proposed by the offerer. E.G1 If a person who is offered to buy a certain goods comes and takes some or all of the goods, or if he pays part or all of the price of goods, such act may be interpreted as an acceptance by conduct. Generally, an acceptance can be given provided the offeree knows the existence of the offer. Acceptance is declaring agreement which presupposes knowledge of the obligation for which the agreement is given. However, if the offer is public promise of reward, the offeree is not known to the offerer, hence whoever performs the promise is considered as if he accept by conduct regardless of his knowledge of the existence of the offer, Art. 1689, 1. Incidentally, Art. 1689 lacks clarity and may be rewritten as follows. Art. 1689 Public premise of reward 1. a promise published in any manner to reward a person who will find an object which has been lost or who will perform certain act shall be an offer. 2. Such offer shall be accepted where a person brings the object back or performs the act, notwithstanding that he did not know the offer. www.abyssinialaw.com. Page 30. Duty to respond, Art 1682-1685. The offeree does not have a duty to give response to the proposal of the offerer. He can respond negatively or positively only if he wants to respond, otherwise he may, for example, read an offer and simply throw it in a dust basket or tear it off by reading only the address of the letter. That means the offeree has the right to remain silent, no one is allowed to disturb his peace. Moreover, if the offeree remains silent, there is no assurance that the offer was brought to his attention, he might have not known the existence of offer. Therefore silence shall not amount to acceptance, Art 1682. It should not be taken as a signal indication of acceptance. However, in the following cases the offeree has a duty to respond and no answer if he does not want to be bound by an offer, otherwise his silence may be taken as a sign of acceptance by the offerer. A duty to accept. Sometimes a law or contract may impose on the offeree the obligation to accept offers made to it. This is mainly when the offeree is a monopoly supplier of goods or provider of services. Some public enterprises are established by law to provide goods and services to the public, hence they are duty-bound to accept an offer from the public. For example, Ethiopian Electric Power Corporation, Ethiopian Telecommunication, Water and Sewerage authorities are expected to accept offer for electric use, telephone line, and pipeline. If they do not want to be bound by the offer, they have to notify within time specified in the offer, if any, Art 1690(1), or within a reasonable time, Art 1691(1). Otherwise their silence is considered as an acceptance, Art. 1683. Private business enterprises may also have a contractual relation with state agency to supply certain goods or provide services to the public, see Art. 3207-3243, which provides about contract of concession. In such case the concession, the contract between the business enterprise and state organ, may lay down the content of the contract that will exist between the business enterprise and the service seeker. www.abyssinialaw.com. Page 31. E.g. Addis Ababa City Administration and Cleaner Private Limited Company agree as follows, Art. 1. Addis Ababa City Administration shall pay bare $2,500,000 to the company at the beginning of each fiscal year. Art. 2. The company shall give toilet service at a distance of 1 kilometer in every asphalt road. Art. 3. The company shall provide toilet papers to the service seekers. Art. 4. The company may charge only 10 cents for one-time use of the toilet service. This contract may be taken as a concession contract as it defines the obligation of the company and the service seekers in advance. So, the offer of the service seeker is limited only to declare his intention to be bound by the contract whose object was already defined, by the government. In short, the offer of the service seeker contains only his intention to be bound and his request to the offeree to agree to be bound. So if such offer is made, the silence of the offeree will be taken as an acceptance. In addition to those bound by law or concessions, a person may have a contractual obligation to accept an offer made to him as per his contractual obligation. This is in line with Art. 1711 and Art. 1957. So in such case also silence is taken as acceptance. So such offeree has an obligation to respond to the offerer if he does not want to be bound by the offer. N.B. The literal meaning of Art. 1683 is that once offer is made, acceptance is automatic. Sub-Article 1 declares that when a party is bound by law or concession to accept, no acceptance shall be required. This is further strengthened by Art. 2, which states that the contracts shall be complete upon the receipt the offer, thereby implying that the offerer can claim performance of the contract once the offer is delivered to the offeree. However, such interpretation seems to be illogical for the following reasons. www.abyssinialaw.com. Page 32. Contract depends on agreement of contracting parties. There is no contract without consent. The level of consent may be highly limited but should not totally be avoided. So the offeree should at least be given the chance to study whether or not the offer has been made as per his legal or contractual obligation. So the mere reception of the offer may not complete the contract and the offeree should be given the chance to say okay or no for the offer. So Art. 1683, 2, indicates date of conclusion of contract only so far as the offer was not rejected. The offeree may lack resource to accept the contract. For example, many customers may apply to Ethiopian telecommunication to get telephone line but the corporation may not have resource to meet the demand. The offeree may have legal or contractual or legal authority to streamline offerers. In principle, Ethiopian Electric Power Corporation has to supply electric power service to every person who demands the service. But when offerers are many, the corporation may give priority to investors. The offeree can refuse to perform his contractual or legal obligation. In such case, the offeree may be responsible for breaking its legal or contractual obligation for not accepting the offer, but it is difficult to conclude that it automatically accepts offer declared to it. Therefore, Article 1683 should be understood as imposing an obligation to respond to an offer. Such conclusion is in line with Art. 1682 and 1684, i.e. Art. 1683 is an exception to the right to remain silent. So Art. 1683 should be amended as follows. Art. 1683 to 2, duty to accept. Where an offeree has legal or contractual duty to accept an offer, the offer shall be deemed to have been accepted unless the offeree rejects the offer within time specified in the offer or where no time is specified within reasonable period. www.abyssinialaw.com. Page 33. B. Pre-existing contractual relation silence may also amount to acceptance where I, the content of the offer is to vary, supplement or complement pre-existing contractual relation. Art. 1684, 1. Variation of a contract means changing, modifying, or avoiding some of the provisions of the contract. Variation of contract itself is a contract and hence needs consent of parties. So, one of the parties may offer such variation. For example, in a sale contract, the buyer may offer to change the delivery date. Supplementary or subsidiary contract is a contract that may exist independently but that help to facilitate the implementation of pre-existing contract. E.g., you bought a cloth and the seller offers you to tailor the cloth, you bought goods and the seller offers you to provide transport service, photocopier proposes to bind the paper it has photocopied, a contractor who builds the house proposes to construct a fence for the same building. Completing a contract means some of the issues not settled in the pre-existing contract be agreed upon again. For example, parties in a sale contract agreed to be bound by the sale, Art. 1695, but not determined place of delivery. Any party to such contract may make an offer concerning place of delivery. If the offer is accepted, it complements or completes the pre-existing contract. Complementary contract is subordinate on the main pre-existing contract. 2. The offer is made in writing. In principle, offer can be made orally, in writing, by sign or conduct depending on the preference of the offerer. But silence can be interpreted as acceptance only if the offerer uses written form of communication that is addressed directly to the offeree. Art. 1684, 2. 3. The offer should be written on special document. Art. 1684, 2. The document that contains the offer should contain nothing else than the offer. So offer written on the back of an invoice should not be deemed to have been accepted by silence. Art. 1685. Moreover, offer should be written on a paper. Email is not a document. www.abyssinialaw.com. Page 34. 4. The offer contains warning that silence amounts to acceptance. The offerer should also expressly indicate in his offer that he considers the silence of the offeree as acceptance after expiry of time limit indicated in the offer. Art. 1690, 1, or reasonable period. Art. 1691, 1, Art. 1684, 2, so if the above four conditions are fulfilled, both the offeree and offerer can claim that silence amounts to acceptance. Exercise. Check the missing element, if any, in the following examples. E.g., 1. Professor McIntosh was employed as a professor in Addis Ababa University for the 2006/2007 academic year. At the end this academic year, McIntosh wrote the following letter to the university: Dear Sir, I want to continue to serve in your esteemed institution for 2007/08 academic year. E.g. Point 2. Bizet agreed to construct a dwelling house for Belay, and while constructing the house, Belay has emailed the following letter to Bizet: Dear Bizet, you know that I myself have been providing construction material. But I am happy if you provide the same for bare 300,000. Please give response, or else I consider it as accepted. N.B. The offeree's freedom of choice of means of communication may be limited either by the offerer, art. 1681, 2, or by the law, art. 1689, 1. The offerer may choose any of the four ways of communication and inform the offeree to use only such chosen means. If the offeree uses another means than chosen by the offerer, the acceptance is defective since it does not exactly conform to the offer, art. 1694, 1. Public promise of reward is accepted by conduct only. www.abyssinialaw.com. Page 35. Effect of acceptance. In general, it can be inferred from Art. 1679 and 1693, 2, that once an offer is accepted, the offeree is bound by his word. Once we know that acceptance is binding, the question that comes to our mind is the moment at which acceptance begins to be binding. In other words, does acceptance begin to be binding at the time the offeree says yes to the offer, or at the time such yes answer is received by the offerer? Such question becomes relevant when acceptance is communicated in writing or by conduct, since in such case the time the offeree writes the acceptance or begins to perform the obligation stipulated in the offer may differ from the time the offer knows such fact. For example, Elmu offered to Abeba to buy his villa for bare 500,000 and Abeba wrote letter of acceptance on January 26, 2008, but such letter reached Elmu on March 20, 2008. Art. 1692, 1, of the Code has answer for this. It provides that acceptance becomes effective from the moment the offeree sends it to the offerer. Here it is not from the moment an offeree writes a letter of acceptance, but from the moment he put it in a post office, or if it is email, from the moment he clicks the send button of his email box. Therefore, the consent element of contract is fulfilled at the moment the offeree accepts the offer regardless of the knowledge of the offerer. This means an offer can be accepted even after the death of the offerer unless the heirs withdraw such offer in accordance Art. 1693, 1. However, the acceptance must reach the offerer or his heirs before expiry of time limit specified in the offer, Art. 1690, or reasonable prior, Art. 1691, 1. If the acceptance does not reach, the offerer cannot know whether or not contract is concluded between him and offeree. If he has not received acceptance within Art. 1690, 1, 1691, 2, he can presume that his offer was rejected. In short, acceptance begins to produce effect from the moment the offeree sends it to the offerer, provided it reaches the offerer within time specified under Art. 1690, 1, or 1691, 2. www.abyssinialaw.com. Page 36. The offeree may abort the contract by withdrawing his acceptance, Art. 1693, 2. He can freely withdraw his acceptance before the offerer knows such acceptance through the medium the offeree uses to communicate the acceptance to him, i.e. if the offerer knows the acceptance earlier than the offeree expects from a friend or other sources, the offeree can still withdraw his acceptance regardless of the knowledge of the offerer. For example, in response to an offer made to him by Bacha, Elmu wrote a letter of acceptance to him and sent it through post office. While sending the letter, Elmu got Gifawosan, a friend of Bacha, and told him that he, Elmu, is sending letter of acceptance to Bacha's offer. Gifawosan told to Bacha that Elmu accepted the offer. Elmu can withdraw his acceptance until Bacha receives the letter unless it is proved that Elmu requested Gifawosan to inform such acceptance, See also Art 1687, A, which provides that declaration of intention is considered an offer only if the offeree knows it from the sources the offerer uses to reach the offeree. For more detailed discussion on this point, please see our discussion on effects of offer, Art 1693, 1. General terms of business. No party can be assumed to be bound by general terms of business which he did not agree to be bound with, Art 1685. General terms of business are internal rules of a party that may have direct relevance to the obligation of the other parties. Such general terms are frequent in employment contract and other big institution which are monopoly suppliers of goods or service. The University Senate legislations are best examples of these general terms of business. Denying legal effect to general terms of business is one means of customer protection. However, if these general terms of business are proclamation, regulation, or directives issued by competent authority, they are treated as law as far as they do not contradict with superior law, Art 1986. To be bound by an obligation one has to know it and agree to be bound, Art 1679. So any annexes to main contract never bind a party who has not known its content and not agreed to be bound. Knowledge about the existence of the annex is not enough. For example, an instructor might have known the existence of Senate legislation which provides more obligations than in the contract he signs. Such knowledge is not sufficient to be bound by such Senate legislation. He must be informed that such Senate legislations. www.abyssinialaw.com. Page 37. Are part of the contract before he signs such contract. Otherwise he can treat the Senate legislation as a morally binding instrument with no legal effect. Moreover, if the instructor accepts such legislation without knowing its content, he should not be bound since he did not participate in defining the object of such subordinate contract, Art 1679. Negotiation versus consent, Art. 1695. Negotiation is when one party proposes to the other some of the contents of would-be contract, leaving the remaining to be completed or proposed by the latter. The latter may also propose some and still leave others undetermined and sends them back. Here both parties may use all possible moral and legal techniques to persuade the other party to accept the proposal or to come up with more favorable offer. So in short, negotiation is a discussion made between parties intending to shape the content of would-be contract. Therefore any proposal made during negotiation is not binding on the party making the proposal, i.e. a party may withdraw from the negotiation at any time, Art. 1695, 1. However, if the negotiation is completed, content of the contract is determined, and both parties agree to be bound by the negotiation, then it ends up becoming a contract, Art. 1695, 1. In negotiation, it is very difficult to know the party who made an offer. However, we may take as an offerer the party who proposes the content of the contract last. Parties need not reach agreement on all contents of the contract. They may expressly agree to be bound by contents of the negotiation, thereby leaving detail to be completed by the law, Art. 1695, 2. For example, parties may negotiate sale of 500 quintals of coffee and agree to deliver on October 25 but fail to reach agreement on price, but the